Hello, good afternoon, and welcome to episode number 37 of At Your Service with Haber and Martinez. Today's show is entitled Electronic Eavesdropping in Florida, Recording and Disseminating Communications and Images. So let me tell you how we got to this and kind of where we're going to go with it. Ed, we didn't have a show. We haven't a show for 2 weeks. Last week was a last-minute no-show because Ed wound up in a jury trial, which resulted in a mistrial. Another topic for another day. But one of the things that Ed had as a evidentiary issue in this trial dealt with certain audio and video recordings, their admissibility, the authentication, how they were covered, how they were going to be admitted or not get admitted, depending upon certain witnesses. And as we tend to do when we have issues that we want to be 100% certain of, a lot of times we run them by trusted colleagues, friends, and associates. And so Ed and I were having a pretty in-depth discussion about these videos. And as it turned out, without getting into that case, because again, it was a mistrial and it's going to be retried, so it's still an open pending issue. But we decided we really need to do a show about audio and video recordings. And then I saw something on the news the other day, a local story that happened earlier in the year, but just got replayed the end of last week, about a Miami-Dade police officer who was questioning a guy outside of a school, and he had drawn his gun while he was doing the questioning, and citizens were recording him. And of course, he should have been using body cam, but as it turns out, his body cam was off because he had shut it off for whatever reasons, yet the video was there from civilians and from other officers that were running body cam. And then there were some words exchanged between the officers and the civilians, which are, of course, all preserved and which you can see and hear from the various videos. And at one point, one of the female officers gets all pissed off and throws a dollar bill at the guy and says, I'll buy your video from you, or some
Oh, it's because he said, I pay your tax dollars.
Yeah, whatever it was,
And
right? I pay your tax dollars, and she throws a dollar at
like, here's your money.
So all of these things led to Ed and I saying we have to do a show on this. And when we started talking about it, it's just so much material. There is so much ground to cover. We're going to have to do 3 shows on it. So we've narrowed down and tapered the topic for today to try and talk a little bit about primarily the electronic eavesdropping, wiretapping laws here in the state of Florida, which have civil and criminal overtones. And so as I have described it, and I'm just going to read this, so bear with me for a moment. If you've already read this on social media as our promo or not, this is the gist of our show today. Imagine for a moment that you're a criminal defendant who is set up by somebody, or you are a litigant that's caught up in a nasty child custody case, or you're being blackmailed by some nefarious sort. Then assume, realizing if you can just manage to get that other person talking, maybe you can secure irrefutable evidence that exonerates you or proves that other person's wrongdoing in the form of an undeniable recorded admission. Perhaps you can get that person who set you up to taunt and laugh at you about how you were fingered for their crime. Or perchance you might persuade a co-parent to admit that they lied just to spite you or in order to get custody of a child. Or maybe you can get an extortionist to reaffirm a criminal intent to get you to pay up or else. Sounds great, right? In the end, and in Florida anyhow, it likely matters not, as regardless of how either virtuous or honorable your intent or motive in making this recording may have been, in each of those circumstances and most others, covert recordings will likely not be admissible as evidence against anyone except perhaps you. Yes, you. Why? Because surreptitious recordings will likely, albeit not necessarily, violate Florida's wiretapping and electronic eavesdropping laws. That said, you got background, you have context. Ed, good to see you today. It's been a couple of weeks. My friend.
Yeah, I want to let everybody know, we were talking about it, and one of the things that we discussed was how often we see videos of civilians telling cops, I can videotape you, and cops saying, no, you're not allowed to videotape. And where really is the line? Because honestly, Mike, I don't know about you, but most of these TikTok Reels videos that I see, everybody's full of crap. The citizens don't know what the hell they're talking about. The cops don't know what the hell they're talking about.
Where's the fact checkers, Ed? Where are the fact checkers?
Well, listen, only if you're Trump. So I thought this is something good to bring to you guys, because that's our goal here is really to work with the citizens and civilians so you guys can get a better understanding. So, Mike, I think where are we starting off? We're starting off with citizens versus citizens.
Well, let's just before we go to citizens for, I think we should start there. But before we go there, let's just take a moment to kind of guide people in the right direction. Florida statutes, there is an entire chapter. It's chapter 934, 934. If
Which
anybody
is a
has any
Florida
interest in,
statute. When
if
Michael
anybody
says
has any,
chapter, that's a statute.
no, no,
It's
no. I'm
tough.
reading. I'm talking about the chapter, the entire chapter 934.
Okay.
So if you just go to Google and you type chapter 934 Florida statutes, what you're going to get is a whole series of statutes underneath chapter 934,
Right.
which is called the security of communications or surveillance.
Right.
And the main one that we're worried about here is 934.03. That is the one entitled Interception and Disclosure of Wire, Oral, or Electronics Communications Prohibited.
Right.
What most people know this law as, and probably the most common lay description of this technical law, and it is technical. If you guys look at this, I mean, I don't care if you have a law degree or not. It's tough to read. It's tough to decipher.
Mhm.
But if you look at it, what you're really going to see is what's called two-party consent or all-party consent.
Right.
And so, as we have talked about, and another show that Ed and I are going to do in the not too distant future, we're going to invite a colleague on from out of state, maybe New York, New Jersey, California, somewhere, some state with their screwed up, goofy laws, and we're going to talk about differences between these states. Gun laws, DUI laws, bail laws. All of these things that can be radically different from place to place. Well, consent in terms of recording conversations is one of those things that varies from state to state. Here in Florida, we have a thing called two-party or all-party consent. And basically what that means is, as a general rule, okay, and it's not specific to every circumstance, but the overriding principle is, if you want to record somebody else, a conversation that you are having with another person or persons here within the state of Florida, then everybody in that conversation needs to first know that they are being recorded and then consent to the recording. Right. If anybody does not consent to the recording, they got to hang up, or if they're recorded anyhow without giving consent, then a crime is going to have been committed. That's right, a crime. That will be a criminal act. We're going to talk a lot about that. That's
and I want to think of this. This is the backdrop, okay? Before I think for the citizens, for civilians, and this goes to all the videos that I see where everybody doesn't understand what the hell they're talking about. The main issue is this. Start with this thought process, period. Is there an expectation of privacy where someone is going to be recorded? That's the first thing you need to ask yourself. Always, first question is it even possible that you could have an expectation of privacy as the person you want to record? Could anybody in that situation believe that they have an expectation of privacy? And if your answer is probably or even maybe, you probably should start thinking about, I need to do this with consent. If you can be 100% sure, there's absolutely no way you can have an expectation of privacy. And Michael and I are going to go through some examples. Then you don't need to tell anybody that you're recording them. And why is that? Think about it. This is the reason. If I can see and hear you with my own eyes and my own ears, and I'm not a private party to the conversation or the video, then what the hell does it matter? What does it matter if anybody else could have heard you and anybody else could have seen you? Who the hell cares if you were recorded video or audio? So that's why you have to start with that basic premise. So everything we go through, you'll see that it becomes a crime where it's somebody who had an expectation of privacy, meaning they didn't think everybody in the world was going to hear or see what the hell was going on. That's where you have to get the consent. All right.
So let's say, for example, that Ed and I are having a conversation right now. You and I are speaking to each other right now. This is a conversation.
Correct.
There is absolutely no expectation of privacy in this conversation. No. Why? We're broadcasting it. Our intent is for other people to see and hear it. Now, if you and I are having a telephone conversation and it's just you and I on the phone, That's a very different discussion than the one that we are having here. And that's precisely what you just pointed out. There could not be a reasonable expectation of privacy. But what if we paused? What if we asked our producer to pause so that you and I could parlay about something, right?
Right.
And then that were published. That may violate that reasonable expectation of privacy because we have evidenced our intent.
Well, and it would depend on whether we wanted if our producer was part of a private conversation, or if he was not part of our conversation, but he was listening anyway. Then there is no expectation. You guys start to see how complicated this can be, and this brings us to the overriding point. Why are Michael and I doing this? To begin with, I had a case. I know you guys like the war stories. When I was a prosecutor, I had a case where a victim recorded the defendant in a conversation. They did it to prove, what the guy what's happening. I had to look up the statute. I was a young prosecutor, Mike, even though I was already in economic crimes, this issue had never come up. And I found that there are certain situations in this statute where even if it's a crime, it's a misdemeanor. Almost every lawyer I know and every judge I know, their knee-jerk reaction to this statute is they think it's automatically always a felony. It's not. However, it's very fact-based specific. So we're not going to get into the details of what makes the difference because it's extremely complicated and fact-based. But the point I'm trying to make is I didn't know myself, and I had already been a prosecutor for 4 or 5 years. I assumed, like everybody else, that it's always a felony. It's not always a felony. Now, most times it is, just so you know. The vast majority of times, the scenarios fall into the felony area. But let's give another example, Michael. I think I like the example we were talking about the you and I having a conversation at a sporting event at a stadium.
Well, actually, hang on before we go there. Let's try this one because it's right up where you were talking.
Okay.
Let's say that you and I are having a conversation as we're walking down the street on South Beach. We're on Ocean Drive. We're walking, past all the shops. There's people sitting in the chairs, eating dinner or having cocktails, walking by us, driving by us, biking by us, flying over us, hovercrafts, this, that. I mean, there's everything under the sun. Yet you and I are just strolling down the street and yapping about perhaps something quite confidential. Turns out there's a guy walking 2 paces behind us recording everything we're saying with his cell phone. We don't know he's there. So that means it's surreptitious, it's secret. He didn't ask us for permission, but he is following us in a public place, down a public street, recording a conversation that you and I are having. Perhaps you and I think nobody else is listening, but we are now on Ocean Drive, walking with hundreds or thousands of people, one of whom is recording us. Lawful or unlawful?
Well, again, is he part of our group?
Nope.
If he is, then it's not illegal because clearly, how can we have an expectation of privacy when the guy's walking right behind us and we're not stopping him?
So now we change it up. You and I are walking. We're not talking about anything sensitive. We get a table at a outdoor cafe and we sit down at our table and we kind of lean in towards each other and have a much more whispered conversation that we obviously do not intend for other people to hear because we're close enough to each other's mouth and ear that we're whispering our secrets. And there's that same person sitting at the table next to us with his powerful mic recording us.
Well, see, there's the key. He's using an augmented microphone for when you said a powerful microphone, which would tend to make the argument that we had an expectation of privacy because the only way he could hear us was by bringing in a special equipment.
Let's say it wasn't special equipment. Let's say he was just recording it with his cell phone.
I think you and I would have a reasonable expectation, maybe, but the argument could be made that how reasonable could it have been if he could record us from the table next to us? So we're in the same situation. We start splitting the hairs, and it depends on the successfulness and the ability of your lawyer to argue it was an expectation of privacy or it was not. And there's where we land.
Let me just reiterate so that the folks are clear, because this stuff really does get confusing. Ed talked about originally that the first thing you need to think about is a reasonable expectation of privacy. He didn't tell you why. I mean, he did, but he didn't. But I want to be clear as to why.
Please, go ahead.
If there is no reasonable expectation of privacy, now, when we use the word reasonable in court, we're talking about an objective standard. That doesn't mean what Ed thinks or what I think or what you think. It means what would a judge or a jury believe that John or Jane Q average citizen would think. So it's the exact opposite of subjective. There are some things that the law mandates subjective belief in. For example, self-defense. You have to, in your own mind, actually believe that you must use force to protect yourself, your property, or another, right? That's the first fundamental requirement. The next step is whether or not it was objectively reasonable, right? I may think I need to use force, but what if all I really needed to do was, slap someone, and instead I pulled out a flamethrower and torched them on the street? It may not be objectively reasonable, my use of force.
No, but it would be interesting. Would be interesting to watch.
Yeah, it's like the 14 Fists of McCluskey. That's where I got that from. So, my point being this: objectively reasonable expectation of privacy means it's one that society would deem as, yes, that makes sense to us.
Right. And
right?
let me throw something else in. Right? Sometimes it's not that complicated. When people video record, so you see these a lot, right? Somebody pulls out a cell phone and they're videotaping a citizen somewhere. And a citizen's like, stop that. You can't record me. I don't give you permission. Horseshit. You clearly don't have an expectation of privacy because you see me recording, and in the very recording, you admit that you know I was recording you. So
that doesn't mean that they don't have an expectation of privacy. They may not. But what it definitely means is it's not clandestine. Right. It's not secret.
And you're not in their home. They're not telling you to get out. You're in a public place. You're in a parking lot. You're in a store somewhere. So they can't say that they didn't know you were recording them. At that point, they have a choice. Stop doing and saying what they didn't want anybody else to hear, or know that you're being recorded and you continue to go on. So some of these are not that complicated, right? Now, if I have a little recording, an audio recording device stuck in my pocket, I could be standing next to someone in a parking lot somewhere that's not within earshot, or hiding behind a car, or somewhere they can't see that I'm there, and they might have the expectation of privacy because, at least it leads to a much more reasonable expectation because they don't see the recording device.
It would also depend on what steps, though, they took in order to suggest that they did have that expectation of privacy. Remember, the famous expectation of privacy Supreme Court case is the one where the guy goes into the phone booth and shuts the.
Right.
I guess many people don't know what phone booths are. They used to be these structures out in public that had payphones where
they still have one at Universal.
You put the Smithsonian too. They put a coin in it. You pick up the phone. You make call. Well, they had sliding doors that you could shut. Now, if you left that door open and had your conversation, you did not exhibit an expectation of privacy. However, if you pulled that door shut, you were saying to the world at that point, I don't want anybody hearing what I'm saying.
Right.
So that's what I mean by objective and reasonable. That's a sign that the public will look at and that the public can say, yeah, this makes sense to me. So your example of us being in the parking lot, it may be that we went behind a car in an area where we intentionally searched and saw that there was nobody and spoke quietly because we did intend to be private. Or we could just be two idiots walking through the parking lot having a conversation, you know, like De Niro and the blonde and Jackie Brown when she wouldn't shut up and he shot her. So, you never know how that's going to go.
Even let's take the scenario where you and I go hide behind a couple of cars in the corner of a parking lot or by the corner of the building. The minute someone walks up to us that's not part of the conversation, that's someone we would not normally want to hear our conversation, we're put on notice. So if they come up to us with a camera videotaping us, you're going to have a harder time saying, so I had no idea they were recording me.
But what we're doing now is we're convoluting two different things, right? One thing is what this act was primarily established for, and that was clandestine interception of audio, of verbal conversations, right? Now, of course, that's morphed over time because you have other types of conversations like email conversations or text messages or FaceTime, right? All of these different platforms that we have. And so now you're commingling audio and video. But let's go back to the basics and just start with strictly verbal conversations, right? Okay. What is unlawful, what is illegal, is to record somebody's conversation whether you are a part of that conversation or not, to record somebody's conversation without their knowledge and consent in Florida is a crime.
Right.
Now, it is not a crime to do that in other states, states that have what we call one party instead of two or all party consent, right? So the example that I like to give is real simple, because virtually everybody has done this at least once in your life. You've picked up the phone and you've called customer support for somebody, an airline, a bank, an insurance company, whatever. You got to push buttons, you got to jump through hoops, you're put on hold. You know, if you're like me, you're wishing you had hair to pull out. But at the end of the call, before you get connected to a live human being, at some point you're going to hear something along the lines that says, "This call is being recorded for blank purposes, customer service purposes, whatever, blah 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 blah." But the point is, they tell you that because in Florida they have to tell you that if they're going to record the call. Right. And it gives you the option to either stay on the phone and have a recorded conversation knowingly, willfully, and voluntarily, or to say, "No, I don't want to be recorded," and hang up. That's your choice. But they're obligated to tell you. Now, they may not be obligated to tell you in a one-party state, but they definitely are obligated to tell you in a two-party state, and they're not going to take that chance. So they disclose. So let's take another better example, one that I used in the promo that you and I can have some fun with.
Okay.
Let's talk about co-parents, okay? Or they don't have to necessarily be married. Maybe they're spouses that are going through a divorce or a custody case, or maybe it's a paternity case. Maybe they were never married. It doesn't matter. Two parents that have a common child and really dislike each other for whatever reasons, good, bad, or indifferent. Not here to judge. Let's just assume that we're talking about
it's an ugly divorce.
Two parents of a common child that have issues, and they are litigating how to deal with those issues. They're in and out of court, whatever. There's allegations made, maybe DCF, criminal allegations, child support failure, didn't pay for this, didn't pay for that, indoctrination, who knows, whatever the hell. We've had David Bonham on here before. We did a show with him. We had Sheila Zolnor on. We talked about family law. We've talked about domestic violence cases, and we've talked about the horrible reality of strategic weaponization in order to gain tactical advantages in family court, right? And so if you're in that position and you are the let's call it the good parent, right? You're the one who's pretty much done everything by the book, and the other one is playing shady games, making bogus accusations, calling DCF. You know, maybe that parent actually belted the child or put a welt on the child or a bruise on the child and attributes it to you and convinces the child to say, "Yeah, you know, Mike did it, Ed did it." This happens all the time. It's manipulation. It's plain and simple. It's horrific. But it's very difficult to disprove, right? Because that little 3-year-old kid's not going to be able to testify in a courtroom and probably is not going to say anything other than what he or she thinks that she's expected to say. And even regardless of what he or she does say, the reason that he or she can't testify anyhow is because a 3-year-old kid doesn't know right from wrong, doesn't understand the concepts of being able to tell the truth versus, describing a fantasy. So the good parent decides, all right, you know what I'm going to do? I'm going to record the exchange when we swap the kid, right? Or I'm going to put a bug in the kid's backpack or in the kid's shirt, right? So I'm going to record the conversations that the other parent is having. And the reason I'm going to do it is because I will ultimately be able to prove that this person completely lied, committed perjury, abused the system, blah, 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 right? You with me?
I am. I'm listening. I got you.
Okay. So let's assume that that's our scenario right now. I record, you and I are partners and we have a common child. And
very progressive of you.
Yeah, why not? Why not? I don't judge. You know, to each their own. But let's assume, and let me be clear, you wouldn't be my type, okay?
I know, I'm too good looking for you.
yeah, that's the reason. So Anyhow, let's assume that I am recording surreptitiously without your knowledge. Okay, we have the exchange. Our court order says that we're to do the exchange at the police department, at the lobby of the police department, or at a statue in the park if there are any statues left in parks.
Let's use one specific. How about we use let's use a restaurant. Let's use a fast food restaurant. And you know why I'm going there, because
okay, so we do
depending
drop
on
off.
where the exchange is,
We do drop off there.
Right,
Fine.
McDonald's.
So I decide I'm going to record it, and I'm recording. You don't know I'm recording, but I'm baiting you because I'm trying to get you to admit that, yeah, of course it was bullshit what you alleged against me and blah 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 blah. But what difference it make? You're going to win, right? Because no one's going to ever be able to disprove it. And I know I just need to get you to say it. If I get you to say it, I've got you on tape, and now I've got evidence I can use to cross-examine you or to introduce proof that my theory is actually correct, because I have no other way to prove that.
Right.
Right? All things equal, I have committed a felony when I recorded you.
Right. Generally speaking, correct.
That's our starting point.
Right.
Now let's talk about how we might be able to do this where it's not a felony or where it's not a crime at all.
Okay, so I'll give you one scenario. I'm wearing a GoPro on my head when I come talk to you. You're going to tell me you didn't know I was recording you? It's that big stupid thing on my freaking head with one of those stupid bicycle helmets. You're not going to be able to say you had an expectation of privacy, Michael. You see the big stupid thing on my head. I really don't have to tell. Now, it's still good practice to say, hey, that GoPro on my head is on. But you might be able to say, I didn't have to say that. He knew I had a freaking GoPro on my head. That's one. How about we're meeting in the parking lot and there's people walking by and I've got a video recording. I didn't tell you I was doing it, but I got a video recording of people walking by, and maybe one or two of the bystanders says, hey, can you guys argue somewhere else? You're going to have an expectation of privacy? We see people walking by. Everybody can hear what you're saying. They can hear what I'm saying. As a matter of fact, somebody even responded that they could hear us arguing. I think you're going to have a tough time saying expectation of privacy. All right, let's look at a couple other scenarios. We pull into the back corner of the McDonald's, away from everybody else. It's just you and me by the car. No GoPro on my head. I've got my cell phone kind of like through a see-through shirt, and it's kind of obstructed a little bit, but I can see your face in the phone, and you can hear there's nobody else around us. I'm not telling you I'm recording, but I've got it in my shirt. That is going to be a felony. And it's going to be a felony because I'm using it specifically with the intention of doing something in a court proceeding. How about this one, Michael? We walk into the crowded now. This one's a test. I know you know the answer, but we walk into the McDonald's and it's crowded. And you tell me, Ed, let's get a booth over here in the corner. And now I don't have my GoPro. I got it in my little shirt. When we walked into the McDonald's, we were surrounded by people and the phone was recording. Then you said to me, let's go in the corner over here in a booth. And I follow you into the booth. Everything that happens in that booth, legal or illegal?
You and I have gone into the booth privately. That's it. There's an expectation of privacy at that point.
And the reason I like the last one is, notice, guys, at the very beginning of the recording, probably would have been legal because we're surrounded by a lot of people over by where.
But we moved into that booth.
But Michael specifically went to the booth, even if I were to say to Michael, let's go to the booth. Obviously, the intention is
privacy.
Expectation of privacy.
So now what if the McDonald's has video surveillance going? Their video is going to be admissible for either of us. What if they have audio and video? You don't usually see that, but let's assume that their camera happens to be right above the booth that we're in, and it's recording absolutely everything.
Nothing illegal. No expectation of privacy. It's not your store.
Can I subpoena that and try and introduce it as evidence against you? Can you prevent me from getting that into evidence in that case?
You could try, but I don't see a judge who would prevent it. I got one.
What about?
I got one. I will let you say yours and see. You might say the same thing.
Well, no, I was going to dovetail on something else. So go ahead and throw yours out.
What if you and I now are separated, and you are dropping off the child at my house? I'm going to start with, let's layer it again. You come to my new apartment, my new house, to drop off our kid, and we're having a conversation in the front door, not with a Ring video, but with my surreptitious hidden phone in my pocket again, outside of the threshold of my apartment in the front lawn. Nobody's around us, but it's out on the front lawn. Nobody is around us. I will make it, I won't quiz you. I think that's an expectation of privacy.
Absolutely, 100%.
Nobody can
But
see us.
what if it was a Ring video?
Wow, now I'm going now. There's one after that. So now let's say that it's a Ring video. It's right there. It's a doorbell. You see the Ring video. I open.
Or maybe I don't see the Ring video, but either way, it's there. It's plain. Right. It's obvious. It's there.
Good point. You may not even see it. I don't even tell you that I have a Ring video, but it's right there. And you're outside of my door, but you're on my porch. Not an expectation of privacy. It's my porch. It's my house. I can have a Ring video. I don't have to tell you that I have a Ring video. You should have noticed it.
Now, I would argue that that is a different story if it's not a Ring video and you have your phone in your pocket or some secretive device that you're recording that I have no way to know is there. Correct. That's the difference in this illustration is it's not, again, what was that magic word that we used? Reasonable, objective. It is not objectively reasonable for me to say, well, I didn't see the Ring video, so I had no reason to know. No, that's my problem, not yours.
That goes to my argument.
Now, if the Ring video were covered, by a plant, what would be the point of having the Ring video? Let's say the Ring video was covered by a plant and it was obstructed, and all we were using it for was audio and not video. Then I think you got a much better argument at that point.
I think you do, but I think you still lose because it's my property. But look, this goes back to what I said earlier in the show. When you got a big GoPro on your head, it's kind of like the Ring video. You can say what you want, but it was right there in your face. When somebody's holding a cell phone like this in your face, you can say I had an expectation of privacy, but you got a cell phone in your face like this, it's going to be hard. It's going to be like the Ring video. But how about this, Michael? How about you and I got separated yesterday? I know it's ridiculous, but let's push the boundaries. You and I were living in our home. We separated, and you left and got a motel. Completely separated. I went and got a nanny cam and put it in the house. My home, my property. You come over, but you used to live there. Up until yesterday, you were living there. But now you come back to pick up the kid, and you walk into the house. And there's the nanny cam. Do you have an expectation of privacy in that scenario? I'll tell you what I would argue.
I think that's a tough one, and it's going to be fact driven. I think there's a good argument to be made on one side that you purposely installed it with the intent to surreptitiously record me. I think there's also an argument to be made if I'm on the lease or on the deed and I am a home owner and I don't have knowledge that you installed that. You know, those are all mitigating factors that will go. But again, I think you come back to that same point that you made right up front. What is objectively reasonable?
Right.
Where is that expectation of privacy? If I'm still, whether I've got a hotel or not, if my name is still on the deed of that house and my property is still inside of that house and I'm still have a key to that house and I'm welcome to come and go inside of that house and I don't know that you put recording equipment in there, that may be a problem for you.
That may be. But then the flip side is I could argue that you left and you left me with the apartment. So that was mine. I changed the locks on the door. If I change the locks on the door, now I've got a stronger argument. You don't have an expectation of privacy. You couldn't even come in. I had to let you in. So the point I wanted to make with this last one is, guys, this. You see how very complicated it can be.
By the way, I still say it's a surreptitious recording, and I still say it's illegal.
But remember,
even in your house. Because I don't think it much matters where you are. It matters whether or not I have an expectation of privacy.
That's what I was going to tell you. It doesn't really matter. All that conversations, surreptitious recording, all that stuff only becomes a factor, Michael, if you don't have an expectation. If you do, rather, have an expectation.
That's the prerequisite.
If there's no expectation of privacy, I can surreptitiously record anybody I want at any time I want. because you don't have an expectation of privacy. You can't argue, I didn't know. You can't go to a football game, sit in the stands in the stadium, and then have the networks take a photograph or take a video of you in the stands and try to sue them and say you had an expectation of privacy. You're not going to win that one. You were in the freaking football stadium. Everybody knows that there's cameras everywhere and you're going to be seen. So you cannot argue that if you're in a public place. And the reason I bring it up, since we're already at 35 minutes, is when I see these people say all the time, you can't record me. I didn't give you permission. Listen, you're on a public street. You're out in public. Anybody can record you, because if someone can see you, they can record you. So don't stop it.
We're going to talk more about that shortly, and the example that I'm going to start off with when we get there. But there's something I want to do before that. Is people on the beach. You're on the beach. You're in a bathing suit. You're scantily clad. Maybe you're topless. Who knows? Where's your expectation of privacy? Can I just sit there with my video camera and record you all goddamn day long if I want to while you're laying on the beach topless? Guess what? I can.
If it's not a private beach, you're right.
That's your choice. You want to go out there topless? That's the price you pay. Can I publish those videos? Can I put them up on YouTube? Guess what? I can.
Yeah.
So now, whether or not they'll allow them to stay up is another story. I guess that depends on how good you look without a bathing suit on, right? So before we go to video, let me just say this one thing, because when Ed and I were researching this, we came across a interesting exception. And there are exceptions to this, and we do need to talk about a few of them. But this talking about civilian to civilian, not law enforcement exceptions yet. But there's an exception here that says this, and I'm going to just read it real quick. It is lawful for a person who is protected under an active injunction for repeat violence, sexual violence, or dating violence, or stalking violence, or domestic violence. So if you have any of those injunctions that you have secured, whether it's permanent or temporary, doesn't matter, or if there is some other, quote, court-imposed prohibition of conduct toward the person, meaning perhaps there's a stay-away order as a condition of bond in a criminal case for domestic violence. Under those circumstances, it is lawful for somebody to intercept and record electronic communications. The recordings can be provided to a law enforcement agency, an attorney, or a court for the purpose of evidencing a violation of the injunction of the court order if the subject of the injunction of the court order prohibiting contact has been served or is on notice. So in other words, if I get arrested for domestic violence against Ed, and before I get out of jail, the judge has to issue a stay-away order telling me you cannot have any contact with Ed, and I then have contact with Ed, Ed will not violate the rule here or the law here when he records that conversation and turns it over to prove that I violated the restraining order or the injunction.
Even if you had an expectation of privacy when I recorded.
In addition, on top of that, one of the things that this statute does, apart from criminalizing the conduct, is it does two other things. One, it prohibits introduction into evidence of that recording in any proceeding. So I may have blackmailed Ed, but if Ed took it upon himself to tape me without going through the law enforcement exception and doing it on his own, his surreptitious recording of my confession is not only not going to be admissible in my extortion case, but it may be admissible in Ed's violation of the wiretapping.
It actually
statute.
would be, not maybe.
Okay. So the one thing that it does, apart from criminalizing, is it prohibits the use. The court can't look at it. The state can't look at it. Opposing counsel can't look at it. It is simply excluded across the board from evidence in whatever proceeding. And then the other thing that it does, apart from that, is it creates a civil cause of action. So you can sue civilly for damages for violating this statute and unlawfully recording someone.
You know something we missed, Mike, when we were talking about, because I know neither you nor I really feel that it's newsworthy. But if they're watching the Johnny Depp Amber Heard trial, they were constantly recording each other surreptitiously without consent. Why is it admissible? Why is it not a felony? I'm 99% sure California is a one-party
Sure.
consent
Yep.
state. So if those recordings were done in California, this is exactly what you get. Pardon my French, you get a shit show. You get people recording you and then doing it out of context, right? So I might piss Michael off and call him all kinds of names and say push his buttons because he's my husband and I know exactly what pisses Michael off and I do it on purpose to piss him off. And then when Michael fucking flies off the handle, I start recording him. And then I'm like, Michael, but why are you so mad at me? I don't understand. Why are you breaking things? This is why I think I love the Florida law better than the California or the one-party consent states, because people use it not only nefariously, they do it in a way to do a gotcha.
And
This
the
way,
other
everybody knows.
thing is, especially if you're somebody with means, right? Like, let's say you're Johnny Depp. I'm actually, I don't want to say Johnny Depp because I don't want to talk about him or his case because I don't know what happened. But let's just say
I don't
you're a
either.
wealthy. Let's just say you're a person who's got means. Money is not a problem. Okay. If money is not a problem, then it's not a problem for you to go consult with the brightest, smartest, craftiest minds in the industry and figure out how to get from point A to point B. And if in fact you are a trained world-class actor, you could probably follow instructions and figure out how to make that happen so that the recording that you ultimately get looks like a Spielberg production, right?
Oh
Seriously.
yeah, that's the problem.
That's
the problem.
that's to your point, but I don't want to single out that case because again, I don't know anything
Yeah, and I'm
about
not
it.
singling out that Amber Heard, did it to Johnny Depp or Johnny Depp did it to her. All I'm saying is what few records I just can't get away from it. So, but the other day I was working and I left. I don't know if it was CNN or Fox. I don't know who it was that had it on, and I just heard how they kept playing recordings and recordings, and you could tell that both of them act like they're the Dalai Lama when they're the ones recording it, and the other one has lost their mind. So you could tell it's just done intentionally. And this is why I'm just saying, if you hear those recordings, that's why in California they're doing it, because they're allowed to do that. That wouldn't happen in Florida.
Can't do that here, exactly. So I want to hit a couple of things in our limited amount of time. I want to talk a little bit about, because we've talked about civilian on civilian, right, in a variety of contexts. Let's talk about law enforcement, because there are clear exceptions in the statute for law enforcement. And you and I have come across this many times in our career. Probably the two most pronounced areas are in the areas of lewd and lascivious or sexual battery cases involving children, where law enforcement will have the child make what's called a controlled telephone call to the alleged to the alleged perpetrator.
Right.
And law enforcement is listening and recording. They prep the child. They tell the child exactly what to say, exactly how to say it. They're sitting right next to him. They're handwriting notes. They're patting him on the back. They're giving him encouragement. And the whole idea is for this child to guilt trip or pressure the subject or target into making an admission on tape, with the cops listening, with the intent of that taped confession being introduced as evidence against, number one, forming probable cause to make the arrest, and number two, then being subsequently used and introduced as evidence against him. So how is it that the cops, and let me say the second way, and then I'll ask the question. The second way that we see this is in drug cases, right? Because a lot of times narcotics officers will do controlled telephone calls with undercover agents or confidential sources and their target. Or when they conduct sting or reverse sting operations, they've got their confidential informant or undercover wired, physically wearing a wire, doing exactly what this statute says you can't do. Right. Wearing a clandestine recording device and recording you in a moment when you clearly have, if you don't have an expectation of privacy when you're conducting a narcotics transaction, you don't ever have an expectation of privacy. But obviously under those two circumstances and others, police are able to sidestep this law. There is a carve out. Why?
You're asking, well,
yeah, I mean, it's a rhetorical why.
In this scenario where you're talking about, all the officers don't even need court approval vis-a-vis a warrant or an order, because it's reasonable suspicion. They're obviously investigating. They can't do it to just some guy walking down the street, but they're doing an investigation. So this is somebody wearing a wire to see if there's any probable cause of the crime. But we're taking a step further. How about bugging, let's say, my cell phone? You know how they you see it all the time, especially in the movies. The feds do it. The state cops don't do it that often because it's very expensive. That's the truth, God's honest truth. That's why they don't do it. State officers is because the budget is limited and it's very expensive. But they were going to record every phone call that I make, Michael. Well, now the law says, okay, wait, that's going a little far. When you got a confidential informant going up to Ed Martinez and asking Ed if he can buy 2 crack rocks from Ed, it's if Ed's not a criminal, he's going to say no. But when you're recording every conversation I have, you might hear me talking about, sex with some girl that I'm talking to. You might hear me talking to my brother about his health problems. You might hear me talking to my mom about my health problems. So, these are conversations that we have a right to privacy. So now the law says, listen, now you got to show the judge that you have a really good basis for doing this.
So wait, hang on a second, because I don't want to confuse the issues. Let's make it clear for everybody. We're talking about Ed's diving into a subcategory of where I started. There's a difference between law enforcement proactively recording a conversation during an investigation that they are conducting, okay? Whether it's a sex crime against a child or a drug trafficking case or whatever.
And it's limited, and the conversation is limited to that investigation.
Correct. There's another larger fishnet that they could throw out. And so what Ed's talking about is wiretapping, where they actually tap your phone, not recording a specific conversation that's planned, but all conversations, right? And in order to do that, they have to get a court order. They're going to have to get a warrant from a judge
and what
that authorizes
right.
the recording of those conversations. And then there's a whole protocol where they're going to have to first establish the probable cause that they have in order to get that. And by the way, under Chapter 934, you'll see all of these types of statutes in here if you want to read them, because it gives the protocol and predicate for things like pen registers and wiretaps and all of those types of things, which again are much more proactive and they're a larger scale operation. And you could think about it this way. I'll give you a pop culture reference that many of you may know. And if you think back to the movie Casino, right? And by the middle of the movie, Pesci's character is completely 100% under surveillance all day and all night by law enforcement. And they have to come up with these codes and methods and have the wives talk on the phone because they know the cops are listening. They know the feds are listening. So they're not going to talk on the phone. But they also know that they can only listen for a certain amount of time. And if they don't hear any topic of criminality, they have to disengage. And then as soon as they disengage and that time period comes, all of a sudden Pesci and De Niro pick up the phone and say, okay, we're going to meet, blah, blah, blah.
And Mike, the only reason I brought it up was to show you how even in that situation, it's still kind of controlled by your expectation of privacy. I'm dealing with a guy asking me for crack rocks. That's part of the investigation. And do you really have an expectation of privacy with that guy and who he might tell that you sell crack? But the other one, where it's just going to record every single conversation I have with every person I speak to, it's not just my expectation of privacy. It would be anybody I speak to, my brothers, my mother, Mike Haber, anybody I speak to. The cops need to show.
Hey, don't bring me into your nefarious
They
nonsense.
need that. But before we go, Mike, we have about 10 minutes. I did want to touch very clearly on something that officers try and bully civilians about all the time. Can you record an officer while they are conducting an investigation in public? Yes, you absolutely can. Positively. Can't stress that enough. Record them. The only reason they can stop you is if you are somehow hindering their investigation. And there's a litany of excuses.
But again, what's good for the goose is good for the gander. It's got to be objectively reasonable, right? Because a lot of cops are not objectively reasonable when they start barking at citizens to shut your cell phone, get away from me, leave this area. No, they can't do that. You're a citizen.
You can't talk to the person they're investigating, right? because that would be obstruction of justice. They're doing an investigation. So, Mike, they pull you over and they're doing a DUI or they're investigating a burglary or car, whatever
and the passenger gets out of the car and starts making a scene.
Or even me, I'm walking down the street and I'm across the street, way far away. Well, not too far, but not too close. And I start yelling, Mike, don't answer him. That could be obstruction of justice. Getting too close to the scene.
Right, but we're talking about recording. Okay, we're talking about recording.
We're not
talking about obstruction.
Getting too close to that. But what they can stop you from recording is if you're obstructing justice. That's the only way they can stop you. So getting involved in the investigation is a way of obstructing justice.
When we do that, when we do a show on body worn, we're gonna show the video that we were talking about where the female officer throws the dollar bill after the tax dollars come in, because they talk about not recording. And by the way, that was one where the BWC on one of the officers wasn't working. So I want to get into all that in a show where we could really talk about that.
Okay.
But I think your point of saying to the folks, again, you are not committing a crime if you are from a distance and without interfering recording police. If you are sitting in your car, if I get pulled over and a police officer walks up to my window and says license, registration, whatever, and I take out my cell phone and record that entire interaction, am I committing a crime?
No, you can record that, especially if the.
What if I don't tell him I'm recording
it? If it's coming from within your car, I think you can, because how does he have an expectation of privacy? It's your car. You can have whatever the hell you want. But you can have whatever you want in your car.
So what about his body cam? What if he's got his body cam rolling? Does that change the equation?
No. As far as for you or him?
For anybody.
No.
I mean, obviously his body cam is protected. I have no expectation of privacy from his. In other words, I can't say to him, officer, I demand, pursuant to my reasonable expectation of privacy as a United States citizen and a taxpayer, that you turn off that body cam because I don't want to be recorded.
Right. His body cam is just like the GoPro example I gave you. He's wearing it. It's there. You may argue I didn't know what it looked like. I didn't know he had it, but it's there for you to see. So, and you having one in your car also, he can't say anything because it's your car. This goes back to the example of the home. It's my home. I can put whatever the hell I want in my home. You came into my house.
Audio and video are two different things.
Yeah, but you still can audio. Right? You can audio.
So I want to touch on two things with video real quick before we wrap up, because they're tangentially related, but they're related and they're interesting. One is I want to talk about video voyeurism. Okay? Video voyeurism is where somebody, it's not audio. I mean, I suppose it could be audio, but it's more concerned about the video component. It's where somebody is surreptitiously recording you without your knowledge or consent. Now, again, the expectation of privacy is clutch here, because if I am that creepy guy that is, walking up and down the beach with my cell phone or my camcorder or whatever the hell, recording topless ladies as I walk by and sitting there drooling as I record them, it's creepy, it's disgusting, it's deplorable, but it's also perfectly 100% legal. Now, let's say that I own a restaurant or a sundry shop or a novelty store on Ocean Drive, across the street from the beach, right? And in the bathroom, I install cameras so that anybody who uses the bathroom, I'm going to capture on tape. I point it right at the toilet. I get them taking their pants off, their pants down. That is very different than me being a creep on the beach. That's me being a creep in private, where somebody does have a reasonable expectation of privacy. And that would be what we call video voyeurism. So let me just tell you the 4 elements of video voyeurism. You either used or installed or permitted to be used and installed a device that is used to secretly view, broadcast, or record for your own or another's amusement, entertainment, sexual arousal, gratification, or profit, or to degrade or abuse the person being recorded. The victim must be recorded at a time where the victim's body was exposed, however privately. It must occur in a place and a time where the victim has a reasonable expectation of privacy, and the viewing, broadcast, or recording must be done without the victim's knowledge and consent. Right. So if you are a creepy person that does that, and you record somebody who is an adult, it's a misdemeanor. If you record a child, it's a felony. Either way, it's creepy. So that's video voyeurism. The other example that I would give on video voyeurism, and I saw it not too long ago. I don't remember exactly where it occurred, except that it was at a Walmart. But there was surveillance footage from the ceiling, from a camera mounted in the ceiling, looking down at a guy. A woman was reaching up on a shelf to get something off the shelf, and the video from the ceiling showed the guy at that moment take his cell phone and shove it right underneath her skirt. Okay, so she moved, went back, walked away from the shelf, came off the shelf, and he wasn't quick enough in his response, and she caught him. But he denied it. He's like, oh, no, I just fell over. Well, they pulled the security footage and proved that this guy had shoved his camera right underneath her dress. That is video voyeurism, and that is illegal across the board. And the other one that I wanted to mention is we know it as revenge porn, but the actual technical term is called sexual cyber harassment. And basically what revenge porn, what makes it interesting is probably 99.9% of the time in revenge porn cases, the images, the porn itself, the pictures, the videos, whatever they are, were acquired with knowledge and consent. So going back to disgusting the folks about you and I being a couple, if you and I were a couple and we were recording each other or sending each other racy photos because we were, in different places or on vacation, it just turned us on, whatever the reason, that's all legal. That's all perfectly legitimate, right, as long as we're over 18, right? If you're under 18, that's another crime. But if you're consenting adults, you're free to do that. But what you're not free to do is to disseminate that information to any other person on any other medium without the consent and permission of everybody else involved in the photo. So if Ed and I break up and I am juvenile enough to post, pictures that Ed sent on TikTok or social media or what have you, I am going to be violating Florida's cybersexual stalking crime.
Now, what if we broke up and I said, listen, Mike, all those pictures I sent you, I want you to send them back and delete them off your phone.
Yeah, that's a great question. And here's the answer. Too bad, so sad. Once given, you cannot take back the consent of having given me the picture. However, I can't share that picture with anybody without running the risk of violating the law.
How about this one? How about I send you a dick pic unsolicited? We're not boyfriend and girlfriend. We don't have a relationship. I send you a dick pic unsolicited. No expectation of privacy. Because you and I didn't have an agreement.
So here's where it depends, okay? And it's true that the statute says, quote, a person depicted in a sexually explicit image taken with the person's consent has a reasonable expectation that the image will remain private. So if I send you that dick pic and I send it to you, I have an expectation that you will keep that to yourself.
If I'm your boyfriend. But what if I'm not?
I don't think it matters whether you're my boyfriend or not. If I send it to you, if I publish it myself, I've now put it out there for the world to see. But I think there's a very good argument to be made whether I know you or not. If I sent it to you, it was meant for you and for you only. But that's what courts are for, right?
And just let's be crystal clear. You guys are listening. Listen to me. Somebody could make the argument, just like emails and text messages, that you don't have an expectation of privacy because since we don't have a relationship, you don't have any control over what I was going to do with that photo or that email or that text. So be very, very careful about what you send to people that you're just dating or you kind of just met, because they might be able to say, screw you, I'm going to put it all over Facebook. And you might not have a recourse. This is so complicated. I think Mike and I talked about it. I think we knew this was going to be a very complex show. But I think Mike and I talked, right, Mike? We talked about, we think, we want you guys to understand a couple of things. One is hopefully understand where your rights are. But secondly, this is why you got to hire a lawyer that knows what they're talking about. Somebody who's good at what they do. Because something as simple as this, that I see 90% of people on social media think they know the rule. And I know a lot of lawyers and judges who think they know the statute. They're wrong. It's a very, very complex, fact-driven situation.
So I think that's your, your pro tips here really are, don't send any photos to anybody that you don't want the world to see. Okay. I mean, if you do, you're taking that risk because they may commit a crime, but you can't put that cat back in the bag. So, you know, once you send that picture, you can hope for the best, but you better be prepared for the worst. I think pro tip number 2 is if you want something to be private, keep it private. Make sure it's private. Take steps to evidence the fact that you want it to be private. And then if somebody violates that privacy, you may have recourse. Number 3, what Ed just said, if you find yourself in a legal jam and you have issues like this, vet them with somebody who's intelligent enough and cares enough to really give you good, competent, solid, meaningful advice. Because like Ed said, there's a lot of judges even that don't know these rules. They're complicated. And I don't claim to be the world's authority on them, but I can tell you that with Ed and I doing research over the weekend and talking about this, there's a lot of loopholes and technicalities and a lot of things that you can do where a sophisticated attorney, if you do find yourself accused of this, may be able to turn around and get a felony dropped down to a misdemeanor or assert an affirmative defense that's able to put you in a better position.
Or an exception. And by the way, Mike, so the judges and any lawyers that are listening understand, we are not in any circumstance way saying that we're smarter or they're dumber. No. This is so complicated that unless you've ever dealt with this issue specifically, and some judges have never dealt with it specifically. I know, like I've been prosecuting for 4 years when this situation came up. It took me a whole weekend to research it, and I kind of remember, and this happened back in 2006, because I remember reading the statute thinking my victim witness was in huge trouble because they committed a felony. So when I started researching it, I realized, oh, wait, no, they only committed a misdemeanor. Not as bad. So it's not that we're criticizing anybody. We're just trying to point out how complicated something that everybody in the profession thinks is simple and straightforward is not.
Well, I think with that, we're a little bit over time and we're going to have to say goodbye to everyone. But we are going to continue this conversation, and we do need to have another discussion that really deals with body worn, because the law of body worn is incredible. And Ed and I have recently had cases. I have one right now where the state just sent me a memo telling me that the body worn camera malfunctioned. Okay. Meantime, all of these statements and things that are attributed to my client, which should be on body worn, are not there because the body worn malfunctioned. And I don't know if it malfunctioned or not. And when we do that show and we show the video on this officer who intentionally shut his body worn off, okay, then you'll start asking these types of questions and understand how a defense attorney will be able to wield that like Excalibur when we're talking about reasonable doubt. But that's next week. This is this week. I want to thank everybody for tuning in and for your time. Episode 37 of At Your Service with Haber and Martinez has been, I think, very informative and interesting. I hope it wasn't too technical. I hope we didn't bore you. And I'm pretty sure that next week when we do 38 on body worn, will definitely be a little more interesting because we're going to show you some videos and we'll have some fun with that.
Right.
With that said, Ed, good to see you. Thank you again. And I'll look forward to seeing everybody next week when Ed and I are back at your service.